Have you ever added your spouse or child to your bank account or property title? It might seem like a straightforward way to ensure that they have access to your assets and a simple way to avoid probate, but joint ownership in California comes with its own sets of problems and pitfalls. I'm Elijah Keys, certified estate planning attorney. That's like board certified, like a doctor's board certified. I've done more than 3,000 trusts and post-death transfers. I'm here to talk to you about what joint ownership really means. So let's talk about a family. We have James and Laura, who we've been following along in this seminar series. They're married. They own a house in San Jose. They have 2 adult children. James recently added Laura to the title of his car and their main checking account, thinking, if something happens to me, goes to Laura. Easy. Sounds great, right? Well, that's true, but only to a point. What if Laura passes first? What if one of the kids is added to a bank account later? What if there's a disagreement after someone passes? Let's talk about the details of joint ownership and how it really works. So in California, joint ownership generally comes in 2 forms. Joint tenancy with rights of survivorship. That's where if one owner dies, the other owner inherits the asset with no probate. Or tenancy in common. No automatic inheritance. If a person owns a portion, their share passes through a probate or some other method. I want to clarify here that there's a third type that we're not going to talk about today. Community property with rights of survivorship. Normally that's in real estate. So today's discussion is not real estate. We're not going to talk about houses. We're not going to talk about homes. We're not going to talk about mobile homes. We're not going to talk about any type of real estate that you own or live in. That is a different discussion because there's a lot of tax problems that come in. But everything else we'll talk about today. Most married couples use something called community property with rights of survivorship instead of joint tenancy. Similar to joint tenancy with potential tax advantages. So let's talk about what types of property is commonly jointly owned. Well, first you have a bank account, right? It's easy to make joint because the bank will simply put someone's name on the account with you. When you do that, you give them access to the account, but you also give them ownership, and there's some problems with that. We'll talk about that a little bit later. Stay to the end of the video because we're going to show you exactly what that problem is. Second is real estate. You can retitle things jointly, you can buy them jointly, you can transfer them to yourself jointly, but doing so may trigger property tax issues if it's not done correctly. We're going to talk about that in a different video. Also a vehicle. That could be a car, a boat, an RV. Joint title means either party can sell the car because both of them own it. So in James and Laura's case, adding Laura to James's bank accounts helps to avoid probate, but could affect issues in the future and limit their planning options. The benefits of joint ownership are that it avoids probate for the jointly owned asset. It's simple and cheap to set up. You do the transfer yourself. It's done. Provides immediate access to the surviving owner. And it's very common. It's a common way to hold property between your spouses and sometimes even children. So how does this work after James dies? Well, right now, the bank, in our imaginary scenario, has Laura and James on title. Title means whose name is on the owner line. The owner is James and Laura as joint tenants or James and Laura. What Laura needs to do is prove to the bank is the organization that controls that information, prove to the bank that she is now the only owner because the other owner has died. Remember, joint tenancy is a bet. The survivor gets the thing. So when James passes away, Laura has to prove to the bank that James has died. She provides a certified death certificate to the bank, and the bank removes James' name from title. But there are some things that can go wrong with joint ownership. We have to be really clear about that. Number one, we can lose control. Adding someone to your account gives them full access, even before you die. Why? Because they're an owner. If Laura adds her daughter on as an owner of her account, let's say that James has passed, Laura is aging, she needs her daughter to help. She adds her daughter on as an owner to her account. Well, her daughter can now take everything out of that account because her daughter is now the owner of the account. She gave her half of the account. It can also cause gift tax issues. When you add someone onto an account or an asset, you're giving them part of that account. If you have a large estate, this could cause a major problem because you're actually giving them money. And if you have assets over a certain amount, and when we're recording this video, it's 2025. So if you have assets more than 13.99 million, if you're giving money away, you could actually be paying taxes now, or you could be paying more taxes in the future. And so it's important to know what you're giving away, how much you have, and whether there's actually a tax exemption that you can apply. You also have loss of inheritance planning. Once an asset is jointly owned, your will or trust don't control it anymore. The reason why is because you already gave it away. When James puts Laura on the account, James gave her the account. The account doesn't transfer when he dies because that's when she received it. She already received it. When the bank titled it, James and Laura, with rights of survivorship, meaning that the survivor gets the asset, the transfer happens when the account title changes. Your will and your trust can't transfer anymore because you've given away the right to give it to anybody else. You already gave it to Laura. It's done. There's also the risk of the co-owner's debts. So let's talk about what happens if you put a child on an account. If the child has debtors, if the child owes someone money, they get to take that money from whatever source, including your bank account. What you've done now is you have allowed the child's creditor more power against you. Why is that? If your child owes someone money, the creditor, the person who owns the debt, gets to take that money from whatever assets the child owns. Let me say that again. A creditor can take money from whatever thing the child owns, including their car, their favorite watch, their joint property house with the spouse, or the joint account with you. What if you have a lot of money in other accounts? That creditor could take from you knowing that you're going to pay the entire bill. You don't want to lose the joint asset. Let's say you have a boat and you have a joint ownership with your child. You don't want to lose your $200,000 boat, but the creditor is coming and they're saying, look, I'm going to take it from your boat. Now you have to pay the child's debt even if the child can't. It's a really bad decision unless you actually have to put someone on. Joint ownership might not be coordinated with your overall estate plan. Let's say that Laura adds one daughter onto the account. She has given that daughter that money. It's a gift. When Laura dies, her daughter gets the account. What if that account has $300,000 in it? And her overall estate is $2 million. Well, now Laura's daughter gets $300,000. Great. But the rest of the assets are split between the children equally, meaning that Laura's daughter has gotten an extra $300 grand. That's going to cause a lot of jealousy. It might cause a lot of friction. It certainly doesn't work with their plan because Laura made a mistake. What happens when the last joint owner dies? Well, when the last joint owner passes away, that is, of course, if Laura outlives James, James passes away and Laura receives the bank account. When Laura dies later, the assets are no longer jointly owned. So joint ownership only works once. It doesn't work twice. You can't say that James and Laura own the asset together. James dies, the asset goes to Laura, and then Laura now has joint ownership with someone else. It doesn't work that way. Laura has to affirmatively plan her estate. An estate plan is planning for what you own. So a joint asset is a good way to transfer between people at one stage. You have a one-stage transfer between husband and wife, great. Who gets it next? You have to plan ahead. Joint ownership only works once. So when does it make sense and when does it not? Well, when it works well is between spouses with a simple estate. James wants to give everything to Laura, joint ownership might be okay. For small bank accounts or vehicles with no risk, that might be okay too. But when does it not make sense? Well, it doesn't make sense when there are blended families. When James might want to give his things to his children and not Laura's. Or if Laura wants to give her things to her children and not James. Well, that means that James can't put Laura on a joint account because Laura might not give things to James' kids. Laura might want to help her kids and not James. It doesn't work when you want control over asset distribution. So if you want control over where things go after the next person gets it, if James wants to control the distribution after Laura's death, then he needs to not put it in joint ownership. He needs to put it in a trust or under a will or beneficiary designation. In some way, he needs to designate a future beneficiary because when the asset goes to Laura, she designates all the beneficiaries, not James. You shouldn't use joint assets when tax planning is a concern. So again, in 2025, if you have more than $13.99 million per person, or if you need to give away a lot of money this year, then joint ownership is not a good option because it reduces the control that you have over how things transfer and how they're valued. Estate taxes are always charged based upon the value of the asset transferred, and joint ownership does not allow you to affect the value. You need different tools for that. We'll discuss that in a different video. Finally, when asset protection matters. Asset protection is making sure that people either can't find your stuff, they can't take your stuff, or someone else pays for your stuff. And so joint ownership is a real good way to actually void asset protection planning. If you need to protect your things from potential creditors, someone that might take your stuff, then you need to make sure that you don't use joint ownership because joint ownership doubles your exposure. You're exposed and the other person is exposed. So now you've doubled the exposure. Joint ownership is a horrible idea if you have asset protection concerns. Joint ownership can be a really useful tool, but only when you understand how it works and how it fits with your full estate plan. If you're relying on it without understanding the risks, You might accidentally disinherit someone or create conflict in your family. Worst thing is that you might actually lose the entire asset. If you find this video helpful, don't forget to like, subscribe, and share it with somebody who might need to hear it. Your legacy matters. Let's protect it together. Thanks for watching.